Good morning to all of you. I have a great pleasure in welcoming you all today for our webinar. We are talking on significance of notice, agenda, etc., which is very pertinent issue. As you are all aware, whenever we call the board meeting or committee meeting or annual general meeting, the notice is required to be given, spelling out date, venue, and all the items which are to be transformed. SS1 is talking about our board meetings, and SS2 is talking about our general meetings. There are a lot of if and buts here. If we don't do, what happened to the meeting, whether meeting is valid, decision taken is okay. All those intricacies are very much involved in this. Our panelists are going to go through the details and our presenter will be making the things. So I won't take much of a time in introducing it. But today we have our panelist who's actually Khushbu Agarwal. She
Good morning, sir. Good
is
morning,
a
everyone.
practicing company and good morning. Can you change the slide, please? Introductory style. So in fact, there are two aspects. One thing is there from the employee's perspective, we can actually have a look at it, and from the practicing perspectives, that is, the certificates of the secretarial audit, etc., and everything, what are the specific issues while certifying the secretarial audit, the practicing company secretary look into. Those are all the things we are going to discuss. That is the two sides of the same coins. We will be able to do it. I think with the Khushbu's experience of over 9 years in the secretarial compliances, and she's being successfully doing it with the industrial background, and she has been associated with issuing the various secretarial certificates, etc., and other things and all. She'll be able to tell us what are the best practices, what exactly they are looking for, what are the cares we have to take care in a particular issue, etc., and other thing and all. We can actually hear from her. And her extensive industrial background includes a significant tenure as a company secretary and compliance at the Diamond Elements Private Limited, demonstrating her commitment to the corporate governance. And she is also, glad to know, serving as an independent director for Adi Industries Limited and Bindal Exports Limited. And she has got a diversified experience in the various fields, and she is a sole subsidiary consultant in the South Gujarat Chamber of Commerce and Industry. And she also holds the various key committee membership within the professional bodies. That is one thing I am really glad to see. Really, what we are talking, women empowerment, women entrepreneurship, that is really taking off. Hats up to Khushbu. I think we have our expert opinion. I think with this, I'll ask our expert panelist Sudhagar, who always contributes on this field, to talk about the subjects, so that he'll leave the introductory Richard followed by Khushbu. Yeah.
Let Khushbu talk first, Bala, because she is the guest
Okay, no problem.
And after that, I will speak.
Okay, no problem. Khushbu, you can give your introductory remark, please.
Yeah. First of all, thank you so much, sir, for briefing my profile in such a good manner. I am just a fresher for me, and I am going to learn very much from you all seniors. But yeah, I am working with the government sector also. I am currently I am also associated with Silvassa Smart City Limited as a consultant. I am also doing various secretarial works over there. In regard the current topic that we are going to take today in today's session, it is really very much required topic, because in case of notices and agendas, we are missing very critical aspects. That means currently we are using AI, we are using mails to give the notice, but we don't even understand that what should be written in the subject line, and what are the different kinds of meetings, and what are the material aspects that we have to consider while giving the notice and agendas. What are the means what we have to write in agenda. So yes, this is a very critical aspect we have to keep in mind for that. And yes, this is a very information session which will be going to be held today, and thank you so much, sir.
Dipti has joined. Yeah. Yes, Sudhagar, please.
Yeah. Good morning, everyone. In fact, participants might be wondering that we are having an exclusive webinar on notice and agenda. But is that In fact, okay, that 2, 3 of my friends even called me and asked me also, okay, that don't you think it is an elementary topic, to have a webinar on your platform? Sometimes in life, the elementary things which we ignore catch our neck. This is one such issue. In fact, before we devised a webinar on this, I think about 10 days prior to that, I got a call from one of the professionals who, while drafting the AGM notice, he has taken or rather got inspired from one notice of one prominent listed company. And he has more or less copied, if I dare to say that, he has copied that. And ultimately, he has landed up in a soup because there were certain mandatory provisions which were supposed to be there in the notice of the general meeting, which was not there in that. The reason for that is nothing but in the notice from where he got inspired and copied it was also not there. But can he take it as an excuse? The answer is no. And let me say honestly also, if any of the participant, if you put your hand on your heart and say that none of us might be drafting the notice, whether it is of board meeting or whether it is of committee meeting, whether it is of shareholders meeting. The tendency is always to copy that. If we are working in the organizations, what we will do is we will pick up the previous notice, just make some amendments to that and then issue that. This will certainly put us in trouble, if not today, tomorrow, if not tomorrow, day after tomorrow. So, because unless if that notice is proven to be defective, the entire meeting is also going to be a defective meeting, and even the resolutions passed may be challenged. So, the fundamental thing is that issue of the notice, and that should be impeccable, means the provisions all are to be complied with. You may note that when there was a dispute between Mr. Mistry and Mr. Ratan Tata, when it went to NCLT, the first question they examined was whether the notice issued for the board meeting was in compliance with SS1 or not. After that, they have proceeded further. If you file any what's called a case in a court of law, the first thing what they are going to examine is the jurisdiction, whether the court has jurisdiction or not. The same is the case here also. In case any resolutions or any business transacted in that particular meeting is going to be challenged, as a company secretary or as a professional, what we have to see is whether that notice is proper or the notice is defective. If the notice is defective, we have won the war. We might have won the project already. Whatever our objective is there. So as company secretaries, we need to ensure that whichever the notice it is, don't take it as a routine affair, but give the seriousness to that. And no doubt about it, every time you don't need to draft it as if it is a fresh one, but at least that whatever the changes we have to, the parameters which are to be redo, we have to do that. Whether it is several times, in fact, when I was working with Reliance, okay, most of my colleagues used to make the changes in the minutes, in the agenda. Sometime or the other, definitely you are leaving the date, you are leaving the time, or you are leaving something or the other. So one has to be very careful. Even if we are doing a copying also, we have that intelligently, we have to copy that. As Kushbu is mentioning now, AI is coming and people might be depending upon that. Whether it is AI, BI, DI, whatever the eyes may be, ultimately it can never replace the human intelligence. And as company secretary, you have to take the responsibility of the notice. At the same point of time, even sometimes we may not even apply our mind. Do you have the authority to issue the notice? From where do you derive the authority? Tomorrow, if suppose your authority is challenged, you have issued a notice to a board meeting, and suppose if any director asked you from where you derived this authority, do you have an answer to that? There are several issues like this, which we will discuss over the time when Jaswin is making her presentation. I give a pause here, request Bala to take it forward.
May I intervene? Sorry for
Oh,
delay.
sorry, Deepti, you have joined. Sorry, I have just seen you. Yeah, go ahead.
No, not an issue. Just to mention that not only statutory compliance and where non-compliance, See, it's like a doing particular action or corporate action. For that, notice agenda is there. If there is a defect in that, you will turn entire meeting or particular all the transacted at that meeting or particular transaction invalid. It's a big blow. So we have to be very careful. In addition, I look at go ahead further. You know, you draft notice agenda in such a way that you create a tone for that particular corporate action. You want the approval from the board or members and all that. So your language and drafting in such a way that give positive tone why you are doing this business, what is the purpose and all that. So please, and if you work out that way, your minutes drafting becomes so easy. It's like additional. You can draft the minutes in 24 hours also with good notice agenda. With this, I'll request to start the presentation. Thank you.
Dipti and Sudhakar, both of you well said this point. Actually, the drafting is very, very important. In one of the private companies which I came across is they drafted the agenda instead of mentioning, appointment of the additional director by the board. He has mentioned appointment of the independent director in the agenda. And ultimately, in the meeting, the preamble also stated the appointment of the independent director, but the operative portion of the resolution that actually said they are appointed additional director. And accordingly, the additional director, DR 12 was filed actually. And subsequent from the regulator point of view, when they have gone, they said, what was the intention? Appointment of the independent director or additional director, what is it? Another thing. And second thing, what has happened is they have said actually the material fact is actually defective. It is the disclosure is not made properly, etc. Another thing and all, you have done a mistake. Then they have booked a criminal complaint against the company and the company secretary and the director, and also the person who's certified, the practicing company secretary, that he has not gone into the details and examined the things rightly and he has certified falsely. He has been also issued the criminal notice. Case has been lodged in the criminal court and the case is still going on actually. So that is the issue which is there. One has to be very, very careful. As you rightly say, drafting, it is very, very clear. We need to understand what is the intention, what is to be done, what is the that is need to be there here. That is the thing. We got preamble says, okay, to start the presentation, go ahead.
Thank you. Welcome, Khushbu. Sorry, I was not there. Thanks a lot for your time, Khushbu.
Thank you so much, madam, for inviting me.
Thank you. Yes, Sudhakar.
Before you start your presentation, Jaswin, let me also say one more thing which I have forgotten to say, that whenever a board meeting notice or a AGM notice, whenever you are drafting, two things you have to keep in mind. Number one, of course, provisions of the Companies Act. Number two, certainly SS1 and SS2 comes into picture. Being a person associated with the Secretarial Standard Board for over 10 years, I must say that I request every one of you, I advise every one of you that please go through the SS1 and SS2 periodically. Don't think that once I read that SS1, now I am a master of it. Just like the way you have to understand Bhagavad Gita, you have to repeatedly read that. Same is the case with SS1 and 2 also. Whenever you are in trouble as a company secretary, who can save you is going to be SS1 and 2. Please take my words. God forbids, whenever you are into trouble, look into these two simple documents. You will find a solution for that. I can assure you, I can give it to you in writing this thing. Yeah, with this, please go ahead this way.
And guidance notes, Sudhakar.
Of course, obviously.
Yes, keep the guidance notes also in hand.
It's wonderful guidance note. All your practical questions is attended by us in that guidance note. Thank you. Yeah.
I also want to add something here. Sorry to interrupt here. Actually, now the fresher CS, they are taking the help of Chat GPT also and many AI tools to do that drafting and notice copy paste work. As Sudhakar sir told that we are doing only that copy paste work. I would suggest to those freshers CS that it's good, no issues. You can use AI tools, but apply your mind also for that, because these AI tools exactly don't know means what are the laws. They can means some amendments can change the entire subject of the thing. So that is also my suggestion. Maybe we can use AI tools, but with applying our mind.
Yeah, thank you. Yeah, Jaswin, you can start now, please.
Thank you so much. Good morning to the esteemed panelists and all the participants. And I would like to thank Mehta and Mehta for giving me this opportunity on presenting on this very important topic, especially as we are around the time when a lot of board meetings and shareholders meetings are being convened and called. So, is my screen visible?
Yeah.
Yeah, very much, very much.
Yes. So the topic for today, as has been detailed by our panelists, is the significance of notice and agenda for the board, committee, and general meetings. So this has been divided into 3 sections, which talks about the board meeting, the committee meeting, general meetings, and any other kind of meetings, and the important points to be taken into note while drafting the notice and agenda for the same. What is the purpose of the notice and agenda is the first question that is to be asked when we start drafting the notice. So a notice and agenda is a very essential component of a duly convened meeting. As Bala sir and Sudhakar sir, as well as the other panelists have also detailed, that if the notice itself is not sufficient, then that invalidates the entire meeting that is held. So, notice and agenda becomes a very important part of a duly convened meeting. It provides information to the attendees relating to the day, date, time, and venue for the meeting, and also provides option, if available, for attending this meeting through video conferencing. More importantly, the notice and agenda sets the intention for the meeting as to what is the agenda item or what are the businesses to be transacted during the course of the meeting or discussed during the meetings. This enables the attendees of the meeting to come prepared for the meeting.
1 minute, Jaswin. Just 1 minute.
Yes. Yes, sir.
Jaswin has mentioned just now that the third box provides details for meeting by video conferencing. She said that if available, answer is not if available, it is mandatory. The company is under obligation to provide a video conferencing, and the director has a right to attend the board meeting through video conferencing. In fact, when Companies Act 2013 came into force, it was interpreted as if it is the company's right. If it feels like it can provide the video conferencing facility, otherwise, no. If you please go through the SS1 as well as the guidance note also. When we have submitted it at the time of approval of SS1, the ministry was very clear that your companies are under obligation to provide the video conferencing. That's why in the notice, it is mandatorily you have to write that the video conferencing provision is there. If any director wants to avail that, kindly contact the company secretary or you put a mail to her, blah, 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 and all those things. So it is mandatory to put it in the notice that video conferencing facility is available. If you are not writing that, again, it is a defective notice. Yeah, go ahead.
So starting with the essential items for meeting of board of directors, the previous were generic points. So now we'll go specifically into meeting of board of directors. Statutory provisions related to notice of the meeting of the board of directors, which is section 173 of the Companies Act. This states that the board meeting can be called by giving not less than 7 days notice in writing to every director. And the notice can be sent by hand delivery or by post or by electronic means. The meeting of the board may also be called at shorter notice to transact urgent businesses, subject to the condition that at least one independent director, if any in the company, shall be present at the meeting. And in case of the absence of the independent director, the decisions shall be final only if they are ratified by at least one independent director. This has been further discussed in the secretarial standards, which we are going to take up.
Just 1 minute.
One more thing is there here. When you are saying a shorter notice, there has been cases in the past also. The shorter notice should be reasonably a shorter notice. You should not be unreasonably a shorter notice, making the director not to attend the meeting. That is also there. Yeah. Yes, Sudhakar, you wanted to say
See,
something.
yeah, one more thing also, apart from the accuracy of the notice, the second most important thing is service of notice also. And the service of notice has just been rightly mentioned. Section 173 says that notice can be sent by hand delivery or by post or by electronic mails. That means you cannot service a board meeting notice by courier. If any of you are servicing the notice by courier, it will amount to a defective service of notice. So please ensure this. AGM notice, initially there was a problem there also. Prior to, I think, 2017 Amendment Act, you were not supposed to service even the AGM notice, sorry, the annual report rather, let me put it this way, because normally notice used to be a part of that. You cannot send it by courier. It was incurring a lot of cost and that delay in the postal services and all those things. Ultimately, in 2017 Amendment Act, if I am not wrong, they have also amended that by courier. But that thing has not been done for service of board meeting notice. So please don't service board meeting notice by courier. Ensure that it might be a hand delivery or by email or by speed post. So by post means ordinary post or speed post, but you have to have a proof of that. So you better always go by speed post. Yeah. So these are the final points. One has to
And
be very
when you
careful
say
about it.
when you say a proof of post, if they said about ordinary post, if you're having a under certificate of posting, that is not recognized as a proof actually in many cases. Because they say that can be generated, that cannot be accepted. That is also there. So one has to be very, very careful. When we talk about the intricacies, the topic looks very simple, but see the intricacies which are actually coming out. Yeah. Yes, Jaswin.
Yes. So Secretarial Standard 1 on meeting of Board of Directors, where it talks about the authority to convene a meeting. So any director or company secretary of the company may at any time summon a meeting of the board. And if there is no CS, any person authorized by the board in this behalf on the requisition of any of the director may convene a meeting of the board. And such meetings shall be convened in consultation with the chairman, managing director, or whole time director, unless otherwise provided in the articles of the company.
Again, 1 minute. See, this is another important provision. It says that any director oblique CS of a company may at any time summon meeting of the board. Just when this is wrong, any director of a company may at any time summon a meeting. Company secretary cannot summon a board meeting. Only a director can summon the board meeting. So normally what happens is always it is the company which convenes the board meeting. The secretary seeks the permission of the chairman. In his absence, any of the executive directors. Because quarterly you have to have one meeting and it is the responsibility of the company secretary to ensure that. So always the initiative is from the company side. However, a director is having a right to ask the company to summon a board meeting. Now the question comes, who he will ask? He may not ask the chairman, he will write to the company secretary, look, I have certain issues to discuss, please convene a board meeting. So what the company secretary has to do, he cannot just call the board meeting like that. He has to go to the chairman or he has to go to the executive directors. He has to seek their permission before doing that. Suppose the chairman says, no, don't convene the board meeting. What the company secretary has to do? Obviously, he has to communicate that to the person concerned. Let me also say that the director himself can issue a board meeting notice. He can convene the board meeting if the company is not doing that. Second question is, in the last line, you also said that unless the articles otherwise provide. So it is the responsibility of the company secretary. Merely don't go to the chairman and seek his permission to convene the board meeting. Please refer to the articles. Are you, as a company secretary, under obligation to convene the board meeting? Suppose if the article says that if any director asks the company secretary to summon a board meeting, the company secretary is under obligation to call the board meeting. Though as a what's called custom, you may seek the permission of the chairman by keeping him posted about the happenings. But if the chairman says, no, don't convene the board meeting, but if you are under obligation under the articles to summon the board meeting, you have to do that. So this is another important point. So as a company secretary, to understand your obligations, you have to be thorough with the articles, especially in case of board meetings. Apart from the Companies Act provisions, apart from SS1 provisions, you have to be also thorough with the articles as far as the protocols of board meetings are concerned. Yes, Jaswin.
So notice of the board meeting shall be issued by a company secretary, or where there is no company secretary, any director or any other person authorized by the board for such purpose can issue the notice. The notice shall specify the serial number, day, date, time, and the full address of the venue of the meeting. And the notice shall inform the directors about the option to available through electronic mode, which is the compulsory mandatory requirement as already detailed by Sudhakar sir, and provide all necessary information, enable the director to exercise this option of appearing through electronic mode. The notice of the meeting shall clearly mention a venue, whether it's a registered office or otherwise, and all the recordings of the proceedings of such meeting, if conducted by video conferencing, shall be deemed to be made available at such a place where the meeting is being conducted. The notice shall also compulsorily contain the contact number or email address of the chairman or the company secretary or any other person authorized by the board to whom the director shall confirm regarding his or her attendance being through video conferencing. And in case of no advance communication or confirmation from the director, it shall be assumed that he will attend the meeting through physical means. In fact, in the beginning of the year itself, certain directors can mention that they will be attending meetings through video conferencing. The notice of the meeting shall be given even if the meetings are being held at a predetermined dates or at predetermined intervals, which is a practice followed by most of the company of creating a board calendar. Yet they have to compulsorily service the notice of the board meeting. Time period for service, the notice convening the meeting shall be given at least 7 days before the meeting, unless the articles provide for a longer time period for the same. And in case the company sends the notice by speed post or by registered post, in that case, we have to take an additional 2 days time period for the purpose of service of the notice. So if it is sent by post, it will be 7 plus 2 days. The notice of an adjourned meeting shall be given to all the directors, including those who had not attended the meeting on the originally convened date. And unless the date of the adjourned meeting is decided at the meeting, the notice shall be given at least not less than 7 days before the date of the adjourned meeting. The mode of service of the notice in writing shall be served to every director by hand or by speed post or by registered post or by fax or by email or any other electronic means that is capable of having a proof of service. And the notice shall be sent to the postal address or the email address registered by the director with the company, and in the absence of such detail, the address appearing in the DIN registration of the director. If any of the directors specifies a particular means of delivery of the notice shall be served to such director by that particular means only. Only in case where the meeting is conducted by a shorter means, the company may choose an expedite or a faster mode of service of the notice to such director. SS1 also highlights that the proof of sending the notice and its delivery shall be maintained by the company for not less than 3 years from the date of the meeting.
So in this case, in the third box, as Jaswin has mentioned, if a director specifies a particular means of delivery, then you are under obligation to service the notice in that particular mode only. That means if I am a director of your company and I am asking you, please arrange to service the notice on me by way of a speed post. So at that point of time, if you are sending me a notice by email or by fax, it will be a defective service. So please ensure this thing. If any director is asking you to do that, that means Jaswin also mentioned that 7 plus 2 days. So if you are sending me by speed post, you have to also ensure that 7 plus 2 days. So 9 days before you have to send me the this.
Sir, you are absolutely right. In fact, much before this, all this digital and other things, all of the email was working. We actually decided to send all the notices to the email. But one of the directors, he very categorically said, "Oh, you are all working in what you call Lotus Word Pro. I am working in Word. I can't get your notices and other thing. I can't open. I don't recognize all this thing. Please send it to me only by post." So we had that. Every meeting, I have to generate a physical copy, make a binding folder. I have to ensure it goes by post only to him, to that particular director. Many people used to tell him, "Why don't you read? Why don't you install this? Why don't you?" No. I don't want to switch over to Lotus Pro. You are in Word. You do this. You do this. All those things happen, but I continue to do that. That is very clear. What you are saying is there we'll have to go by what the director wants. Yeah. Yes, Jaswin.
Yes, thank you. So now talking about the agenda and notes to agenda that has to be sent to the directors. So the agenda setting out the business to be transacted at the meeting and the notes of the on the agenda shall be given to the directors at least 7 days before the date of the meeting, unless the articles provide for a longer time period. And each item requiring approval of the meeting at the board meeting shall be supported by a note setting out what are the details of the proposal, material facts that enable the directors to understand the meaning, scope, and implications of the proposal so as to enable them to take a better decision, and the nature of concern or interest, if any, of any of the directors in the proposal. Where the approval is by means of a resolution, the draft of such resolution shall be either set out in the note or be placed at the meeting. Each item of the business to be transacted or taken up at the meeting shall be serially numbered, and the businesses shall be taken in that order at the meeting. The numbering or the serial numbering of each resolution or item shall be in a manner which can enable a cross-referencing. Any item which is not included in the agenda may be taken up for the consideration with the permission of the chairman and with the consent of the majority of the directors present at the meeting. So this is for additional agenda items if the board deems fit to take any. The supplementary notes on any of the agenda items may be circulated at or prior to the meeting, but shall be taken up only with the permission of the chairman and with the consent of majority of the directors present in the meeting, which shall include at least one independent director if the company has any.
Here also, in the first box, Jaswin has mentioned that each item of business have to have a serial number, and the chairman has to take up the agenda items in a serial number. Why this? This is the requirement of SS1. Why this requirement is there? It should not happen. The chairman is taking up the business agenda items at random, his own whims and fancies. Suppose he cannot say, okay, I am now taking up item number 10. After that, he says, I am taking up item number 6. Because sometimes it so happen, one of the director may express his desire to leave the meeting after 1 hour because he got some other preoccupation. That point of time, it should not happen that he should know that in the first 1 hour, what are the items they are going to be taken up. Just to avoid 1 or 2 items, they should not take up on a random basis. That is the reason for that. Number one. Number two, however, suppose, for example, if one director says, I want to leave after 1 hour, can the chairman has the authority to take up any particular item which he wants to discuss during the presence of that particular director? That means after item number 3, can he take up item number 10, which is a very important item wherein the director's contribution is required? Yes, you can do that provided the directors present at the meeting are giving their consent to that. With their consent, he can certainly take up that thing. But at his own whims and fancies, he cannot do that. At the same point of time, so one more thing as far as supplementary agenda is concerned. Supplementary agenda is two types. One is that you are tabling the supplementary agenda item. Another one is you are circulating the supplementary agenda 1 or 2 days before the board meeting. So whenever you are circulating a supplementary agenda item along with the supporting papers, if you have tabled it, please ensure for the purpose of identification, all the tabled items are to be initialed by the company secretary or by the chairman of the meeting. And you have to record that in the minutes also. But if you have already circulated that before 1 day or 2 days before the board meeting, then uh, that initialing of those documents is not required. However, you have to bring it to the in the minutes that the agenda, supplementary agenda item along with the backup papers were already circulated on particular date. Yeah. So these are the final points. Even a practicing company secretary, when he is conducting the secretarial audit, he has to ensure all these things, whatever I'm saying, and the company secretaries who are in service, because they are the people who are conducting and convening the meetings. They have to ensure this. Yeah.
Thank you, sir. Service of agenda and the notes to agenda. The agenda and the notes to agenda shall be sent to all the directors, again by hand or by speed post or by registered post or email or any other electronic means. And the proof of sending the agenda and notes to agenda and their delivery shall be maintained by the company for not less than 3 years from the date of the meeting. In case of an alternate director who is appointed at the board, the notice, agenda, and notes to agenda on the items shall be sent to the original director also at the address registered with the company, even if these have to be sent to even if they've already been sent to the alternate director as well. However, the mode of sending the notice, agenda, and notes to agenda to such original director can be decided by the company. Shorter notice and agenda. So, to transact certain urgent businesses, the notice, agenda, and the notes on the agenda may be given at a shorter notice of time than the time period of 7 days. If at least one independent director is present at the meeting. And if there is no independent director present at the meeting, the decision shall be ratified by at least one independent director. In case the company doesn't have an independent director, then the decision shall be final on ratification by the majority of the directors, unless the decision itself was approved by majority. And the fact that yes, sir.
Yeah, go ahead. Sorry.
In case of shorter notice, it becomes essential to highlight in the notice itself that the meeting is being held at a shorter notice.
Yeah. So here you see that if you see the Companies Act is silent about how many days before the agenda is to be circulated. SS1 has mandated that agenda is also to be circulated 7 days before. Initially, there was a lot of controversies were there that how can SS1 supersede the Companies Act and say that to stipulate the time period for the circulation of agenda. The answer to that is it is SS1 is a part and parcel of Companies Act. It is not separate from that. So under 118.10, if you see that it is SS1 was drafted by the by ICSI and has given the for approval to MCA, and MCA has approved it and mandated it. So because of that, whatever the provisions of SS1 and 2 are there, they are part of the Companies Act only. Then another thing is that, as Jaswin has mentioned in the last bullet, that the fact that the meeting is being held at a shorter notice shall be stated in the notice. Not only that, it is even to be recorded in the minutes also. You have to record in the minutes very clearly that with the consent of the majority of directors, this particular meeting was held at a shorter notice. And this several times this question comes whether the shorter notice is to be taken in writing or the shorter notice consent can be given by orally also. Answer to that is yes, you can give the shorter notice consent even by a telephone also you can take it. But tomorrow, God forbids, even to the secretarial auditor, how you will prove that the consent of the directors have been obtained? So for that, what we used to do when I was in Reliance was, we used to prepare a small consent of the directors, put all the directors' names, get it signed, and keep it on record. So there you will write very clearly that I have given my consent orally, and I hereby confirm that I have given my consent for holding this board meeting being held on so and so date at a shorter notice. So like this, you have to have the backup papers also. Please don't rely upon that verbal or oral consents only. Because tomorrow the directors may say, no, I have not given the consent. What you will do? So because that's why it is better before starting of the meeting itself, while you are taking the attendance register signed by the directors concerned, to also get this particular shorter notice consent also signed by them. Yeah.
Absolutely, you said the right thing, Sudhagar. In fact, while issuing the notice itself, the meeting is being convened as a shorter notice is a must, number one. Number two is before starting the meeting, we take the consent writing from all the directors, their agreement to conduct the meeting at the shorter notice. And third thing, rightly you said, because minutes, when we are talking minutes, is actually the proceeding and the thing what has been done. The meeting has been convened at the shorter notice, that has to appear actually. All these things appears to be very minor, but one has to be very, very careful in taking care of all the places it is appearing, it is mentioned, it is recorded. Yeah.
Kushbu, wherever you feel free, please do give your comments also. Okay. Don't think that I am dominating the whole thing because
And,
of the.
Yeah. And another thing is there,
Actually,
as you, yeah,
actually, sir,
as
I have a concern that you told na, that it is compulsory for getting electronic means for all the directors. So there are few business items that actually can't be discussed over electronic means, like approval of board report, approval of financials.
That was at one point of time, that was under Rule 4. The
Yeah.
Rule 4 has been deleted.
Okay.
Now you can transact any item by virtue
Okay.
of virtual meeting. Earlier, what happened is for 4, 5 items, as you rightly said, approval of your financials, approval of your board report and all, you were to having a physical quorum was required.
Yeah.
Now that physical quorum requirement is not there,
Okay.
any business item you can pass it. This is during the COVID period that Rule 4 has been deleted. Yeah.
Okay.
now everything can be done through the video conferencing. Because we had a situation before the COVID period,
Yeah.
a company wanted to approve the merger and
So that
amalgamation with a
exemption is
particular
still
participants
with
there.
us. That exemption is still not taken away. It is in
No,
continuing phase only.
yeah, because now
It is not exemption, Kushbu. It is not
it is not
exemption. It has been
exemption.
deletion.
It's a
Okay.
deletion. They deleted the rule itself.
Okay, got it.
Because
Got it.
earlier the rule said this particular item cannot be done through the video conferencing.
Yeah.
It can be done only by the physical meeting. That itself has been deleted now. So that means everything can be done through the video conferencing.
And one more thing I want to add, OMVM does not mean WhatsApp. Many things means electronic means we can send notice on the WhatsApp is not the official way of communication.
Yeah, absolutely right. WhatsApp is not the electronic means.
Yeah.
WhatsApp is not the electronic means. Yeah.
Yes. Thank you so much for the inputs.
Already
Yes,
lot of queries have come actually. So I think after you finish this notes and then we can take up the queries. There are a lot of people have already raised the queries. In fact, you'll be also know, Sudhagar, glad to know, almost about 325 participants are there, which shows very clearly, they're learning what is the important, what is the topic. They also realize this is such an important topic. That is the thing. Otherwise, such a high people over there to the participant that itself will signify the importance of this topic. Yeah.
Okay.
The secretarial standard
Yes,
one
go ahead,
also,
Jasmine.
also mentions the notes in case of unpublished price sensitive information is being dealt with or discussed at the meeting. Then in that case, how should the notes be serviced? So the notes on items of business which are in the nature of unpublished price sensitive information may be given at a shorter period of time with the consent of majority of the directors, which shall include at least one independent director. and the general consent for giving notice on items of the agenda in the nature of unpublished price sensitive information at a shorter notice may be taken at the first meeting of the board of directors held during a financial year, and also whenever there is any change in the directorship of the company. Where a general consent has not been taken by the board of directors, the requisite consent shall be taken before the concerned item is taken up for consideration at the meeting itself, and the fact that the consent has been taken shall be minuted. Along with the Companies Act provisions on secretarial standards, I think Sudhakar sir already highlighted on this that the articles of association in any particular shareholders agreement of the company shall also be thoroughly read before drafting any notice, because many a times, especially where there are particular investor rights, the articles or the shareholders agreement mention particular provisions related to notice and service of the same. So this is an important part that has to be checked.
We just add 1 or 2 points here also. That when you talk about the shareholders agreement, mostly it happens in case of joint venture agreements, that affirmative vote of the joint venture partners for any decision taken at the board. What are the affirmative voting items that is there in the shareholders agreement? And please remember that unless until that shareholders agreement clauses have been captured in the articles appropriately, otherwise they have no validity. That might be an agreement between two shareholders, but the company has nothing to do with that. That's why in case of joint venture companies, whenever the joint venture agreement is there, the clauses of understanding between the joint venture partners are to be captured appropriately in the articles of association. Suppose in that articles, if they say that there are certain items of agenda or decisions to be taken by the board requires affirmative vote, means even if it is decided by the majority of directors, but the joint venture partner has not given the affirmative vote, then what will happen is that item is not be decided as such. That's why articles of association is a very, very important thing when you're talking about the board or shareholders meetings. Yes, just
Yes, even from the practicing side, when doing the secretarial audit, it's one of the primary documents that have to be checked before verifying anything else.
Yeah. Sorry, one more thing. Before in the previous slide, if you can go back in the unpublished price sensitive information.
Yes, sir.
Please go back to the. So in this case, what happens is that when you are circulating the agenda 7 days before, say for example, quarterly results, the board has to approve it. Will you circulate the quarterly results 7 days before? Answer is obviously no, because it is an unpublished price sensitive information. Nobody wants to have that kind of exposure risk. So what we have to do it, you have to take the consent of the directors. There are two ways of taking the consent. One is every time whenever there is an unpublished price sensitive information is there, you have to take it. Or alternately, at the first board meeting of every financial year, or you can take it as a general approval from the directors. As and when there is a change in the directors, then you have to take a fresh approval from the new director. That unpublished price sensitive information can be either tabled or can be circulated at a shorter notice also. That consent is to be taken and recorded in the board minutes also appropriately. On the other way of doing that is, normally that's what we used to do in Reliance was, in case of quarterly results, whatever the sensitive figures are there, like your turnover, your profitability, your material consumption, any sensitive notes in the notes to accounts portion, that you can block it, and rest of the items you can give it to the director so that they can go through the rest of the things, and whatever the sensitive items are there, that you can do it. So it is all up to the company how you will be handling as far as UPSI items are concerned. Yes.
One more thing, when it comes to the article of associations, I just like to share one thing. In fact, when we were actually what we call a closely held public company before went to public, we had a clause with the parent company. One of the clause in the article is regarding the quorum. The quorum said very categorically, unless until the parent nominated company director is present, then the quorum is not valid. So that means necessarily he has to be present in every meeting, then only the quorum is valid. That means if he is not present, we don't have the quorum in spite of having the adequate numbers, but we cannot conduct the meeting. That was the case. When we actually went to public, this was another issue. As you know, that every end of the quarter, we need to have a board meeting and we need to publish the unaudited financial results. So we have to amend this particular clause. When we went to the public, we amended the article in such a way for a particular meeting, either the parent company or the director himself concerned, he can actually waive off that particular quorum so that we are able to make the meetings and we can publish the information to avoid the non-compliances. So it is very important to go through the article, what is there in the article. If there is any such things are there, one has to be very careful in amending the article suitably. Yeah.
I will just add one thing that, what you can have tendency is to mention reference of article in your resolution. So what will happen? You want to check there are provisions which require provision in article, power in article, JV agreement. You will by habit will refer to article, and the skipping on our part in hurry, not by mistake, reference to article can be avoided. This is the convenient way of doing it. Thanks.
Yeah, good suggestion. Good suggestion, Tripti. Great. Yeah. Yeah, Jasmine.
So before I move on to meeting of the committees, would you like to take the questions that are
Yeah,
there?
yeah, we will do that. Lot of questions are there
One
already.
minute, Bala.
Yeah.
1 minute. Before you take up these questions,
Yeah.
even regarding the board meeting, there are 3-4 things which are to be taken care. Number one, especially whenever you are convening a board meeting in a hybrid mode or in a virtual meeting, please ensure that it is the responsibility of the company secretary and the chairman to ensure the integrity of the meeting. Integrity of the meetings means whatever the rules are there as far as your video conferencing meetings are there, those are to be complied with. One of that is the quorum should be presented throughout the meetings. So whether it is a physical meeting or a meeting in a virtual mode, every time whenever you are taking the decision, you have to ensure that proper quorum is present. Most earlier, it used to happen that people used to be there only at the beginning of the meeting, and in between, people used to drift out. That is not, allowed now. Number two, in case of video conferencing, the directors who are attending through video conference, they have to give an affirmation. 4 affirmations they have to give. Number one, that they have to say that from where they are attending the meeting, which destination from they are attending the meeting. Second, they can see all the directors who are there and they can hear every of them clearly. Third, they have received the notice and agenda papers well in time. And fourth, they have to give an information that apart from apart from the director himself, no one else have the access to the proceedings of this meeting. These are the 4 affirmations they have to give. And certain times I observed that while giving these affirmations, the director never switch on the video. Lot of people have this problem whenever they're attending this meeting in virtual mode. Jasmine is laughing because she herself also know that in our partners meeting, people don't switch on the videos. So the directors, I have observed that they were not switching on the video when they're giving the affirmation. In fact, when I was there in Reliance, we used to repeatedly ask the directors, please switch on the video at least when you are giving the affirmation, if not throughout the board meeting. Please ensure that. And finally, that the chairman has to summarize the decisions taken while he is concluding the board meeting. And that summarization is to be also properly recorded in the board minutes. One contentious issue which always grapples with by the company secretaries are whether the recording of the virtual meeting, a director, whether he got a right to ask for a copy of that recording. Answer to that is clearly no. The director cannot ask for the copy of the recording. Nobody can ask for that. A board meeting minutes can be inspected by the director. He can also ask for certified copy of the minutes of that, because anyway, as per SS1, you have to give that within 15 days of signature of the minutes, unless until it is waived by the directors concerned. But a director cannot ask for the copy of the recording. Let me also say that, can a director record the proceedings of the meeting, audio recording I'm talking about, without intimating? If anybody is just switching off the phone and recording that, you cannot help. But if they are formally wants to record, any director wants to record, and please give me the permission, I want to audio record or I want to video record, they don't have any kind of a right to do that. These are certain issues. I have handled that during my what's called as a service in my previous companies. At one point of time, this question has come up. The director said that, look, I want to record the proceedings of the meeting. And we have examined that, and ultimately we said, no, we don't allow the recording of that. Only a company has under obligation to record the video conferencing meetings. Otherwise, if it is a physical meeting, even the company has no right to record that thing unless until, what is the purpose of that? Suppose, for example, if the physical meeting is being taken, that is to be recorded, then the permission of the directors is to be taken by informing them under for what purpose that meeting is being recorded. Because please remember that board meeting is a legal meeting. Everything, whatever is happening except service of coffee and tea, everything is to be go by the rule book. Okay? Yeah.
Okay, we will take up the questions now. Request the panel to throw light to the benefit of the younger members and the professional of the importance of agenda notice actual meeting, sharing the draft minutes and certified minutes with some practical example, how it will actually save the company and the company secretary in case of the dispute in future, specifically when difference of opinion arises between the independent director and the company, and on any resolution approved or board, more specifically in the listed companies. Okay, this is the remark which we are discussing it. What should be the case in case of the company? There is no requirement of the ID. No, ID requirement is there. This is not applicable here because the ID requirement is there only in the listed companies and also specified companies. Of course, when it is come to the private company, it is not, the ID is not required. But the thing is, if we are talking about the shorter notice, of course, the other directors' consent will be required. Yes, Kushbu, you can add something on this. You want to share
Yes,
something?
in case if there is no requirement of ID in company now, then permission of majority of directors is required for shorter notice.
What if the notice issued for the physical meeting and a meeting date, director requested for the join the meeting through the VC? While issuing the notice itself, it has to mention actually that VC facility is available and people can join through the meeting. You have to provide the link, etc. I think that is the requirement. It cannot be on the suddenly on the particular day somebody can say or something like that. That's what I think. Sudhakar, you may like to add.
See, when you are issuing the notice for the board meeting, you will say that on so and so date the board meeting is being taken place. And if any director wants to join through VC, they can join, and you have to inform to the company secretary in advance so that the arrangements can be made.
Why clear those notice is required for approval of the financial result in case of the SEBI LODR regulations? Please clarify whether 7 days notice requirement for the board meeting here.
Yeah, obviously you have to comply with both the regulations. So you have to issue the board meeting notice of 7 days so that the 5 days cleared is already covered in that only.
How the independent director ratify the decision? I think once the meeting is over, you have to communicate to them what are the transactions, the resolution, etc., which is taken with. It has to be sent, and after going through it, you will ratify. That is the procedure, I think.
You
Yes.
have to circulate the draft minutes to the independent directors, and then you have to take his ratification in writing.
Yeah. Only register post and the speed post is accepted. Yeah, that you said actually. Under the certificate of posting service also discontinued. The service was officially discontinued January 31st, 2011. Okay, this is for information. Yeah. Does shorter notice consent need to be in writing from all the directors, or it is the director attend the meeting in the shorter notice, it will be deemed consent? Oral telephone consent taken This I think we discussed enough. He told actually whatever it is, oral is also possible. But the thing is, tomorrow to safeguard, we need to have in writing. That's what we discussed actually. The meeting is held as shorter notice without having the written consent of all the directors. That also we discussed. If the meeting held as a structure without having the shorter notice, all the directors and the minimum one ID is not there in the meeting. How the ratification? Yeah, the same question which you said actually. Whether the director can summon a board meeting directly when there is a company secretary is there.
I said that, if the company secretary is not convening the meeting, then the director who is asking to summon a board meeting, if the company is not obliging him, he himself can convene a meeting also.
Can the person authorized to convene the board meeting be employee of the group company?
See, normally it is the company secretary who has this right to what's called as convene sign the notice, or alternately, you have to authorize the directors to sign the notice. But now the question of employee of the group company, if the board is taking a decision like that, it can do it. There is no prohibition as such.
In one of the company, notice of the board meeting are given well in advance, but the agenda papers are invariably sent 2-3 days prior to the board meeting date, and the financial statement a day prior to the audit and the board meeting. All the independent director attend the meeting and ratify the receipt of the agenda papers and the shorter notice. This is happening regularly. Since the board members, including the independent director, agree to such a practice, is there any violation or any of the provisions of the Act?
See, this amounts to service of the agenda at a shorter notice. And it is not only the independent director's ratification is not here important. It is what is important is the consent of all the directors for issuing that agenda at a shorter notice is required to be taken.
Person should be authorized by the
Ratification, one minute, Bala. Ratification is for the purpose of convening the meeting at a shorter notice. Circulation of shorter meeting notice or circulation of agenda at a shorter notice is two different things. Here, ratification won't do. Here, consent of the directors is important.
person should be authorized by the board to issue the notice means it can be done by passing of the resolution and authorizing for all the meeting or any of the director or CS or any other way authority is to be taken every time the notice to be issued for each such board meeting.
Board has to declare once and for all. Not every time you cannot say that who will be signing that board meeting notice at all.
Is it important to serve the notice to the director who signs the notice, that is he himself?
Yes, of course.
Does electronic means include sending via WhatsApp? That I think we discussed actually. Notice is to be sent 7 days before meeting. So will it be 7 + 2 + 2 days, just like a general meeting or any other criteria?
See that in case of board meeting notice, unlike shareholders meeting notice, they have not used the word 7 clear days. In case of shareholders meeting, they have used the word 21 clear days. So in case of board meeting, if you are sending it by post, 7 + 2 days, otherwise it is 7 days only.
And
Okay, so
I would like to add here, date of sending of notice and date of meeting shall be excluded from the calculation of that 7 days.
So you meant to say 7 + 2 + 2 or 7 + 2?
Here it is written 7 + 2 + 2 days. That is
So
7 +
what is your view? 7 + 2 or 7 + 2 + 2?
My view is 7 + 2, and actually
Yeah.
not 2 also, because it is not mentioned 7 clear days. But in that 7 days, the date of sending of notice and date of board meeting shall not be included. That means 7 days, and in the between, we have to count the days.
I think SS1 guidance note is actually given the example on this, actually how to calculate the 7 days.
See, what it says is, suppose if I am sending the notice by email, today I am sending it, and after the 7th day, if the board meeting is there, that is sufficient. I don't need to exclude the dates. Sending and then the meeting date, I don't need to exclude. So 7 days notice is sufficient. Only thing is, if you are sending it by post, you have to add 2 more days to that. 7
Correct.
plus 2 dates. Whereas
Correct.
in case of AGM notice, in SS2 it is clearly mentioned also, there you have to exclude the date of dispatch of the notice and date of meeting. You have to exclude. And if you are sending it by post, you have to add 2 days. So there it is 21 plus 2 plus 2, total 25 days notice is required. In case of board meeting, if you are sending it by post, only 7 plus 2 is required, not 7 plus 2 plus 2.
Correct. Correct. Absolutely right.
Yeah.
If a director attends for a shorter period, can this be recorded that consent is for a specific agenda item discussed during his presence?
In fact, this is a very good
I
question.
think
No, this is a very good question. It is actually when you are taking the attendance register, if any director is joining in between or if he is leaving in between, in the attendance register itself, it is to be recorded accordingly. Apart from that thing, even in the minutes also you have to record it. When you are showing the attendance, he was present so time in the minutes. Yeah.
Yeah, absolutely correct. That is what we also used to do sometime when the people used to leave. People used to be time, but sometimes people used to leave. We used to record after this particular address. The
As I told you, in case the chairman is taking up any agenda item out of turn, with the consent of the directors, you have to record that also in the minutes accordingly. After item number 3, suppose if you have taken up item number 10, you have to record that with the consent of the directors present at the meeting. The chairman has taken up item number 10 for so and so reasons. Then you have to record that whatever the proceedings are there. Yeah.
Can notice of the board and the general meeting be sent via courier? I think we discussed this actually. Can a board meeting notice can be sent by WhatsApp? That also we actually discussed. What the receptions, the private reasons for not activated, if blue ticks will receive the proper. No, WhatsApp itself is not there actually. One of the CS actually signed the notice. One of the notice opined that a notice can be signed by the company secretary only if authorized, but the board cannot authorize any other officer if there is no company secretary. No, that is not correct. The board can authorize any authorized person. That is there we discussed actually. If the company takes any other agenda on the meeting for discussion, which are not there in the agenda or notice in that case, the consent of the chairman and the other director to be taken, whether the consent required normally, is it orally and noted in the minutes accordingly, is it fine or proper compliance?
See, if any supplementary agenda item or a tabled item is there, the chairman has to take the consent of the directors present at the meeting itself. And obviously that will be a oral consent, that won't be a written consent. But in the minutes, you have to record that very well, that so-and-so item, supplementary agenda item has been taken up with the consent of all the directors present at the meeting. Or if somebody is expressing a dissent, that also is to be recorded with the consent of the majority of directors present at the meeting. The item has been taken up as a supplementary agenda item, and so director has expressed his dissent for that. That's how it has to be taken up.
Yeah, normally when we circulate the agenda, our last item, normally we say actually any other item with the permission of the chair. That is why we put. Once the business are over, then specifically the question asks any other items is there. Then that any other item separately we put the heading. The item transacted under the head any other item, as you rightly say, yes, it gets recorded. That's right.
See, Bala, it was prior to 15th July 2015 when the SS1 came into force. Because prior to that, it was any supplementary agenda item, it was with the permission of the chairman only.
Yeah, now it is on. Yeah.
After SS1 came into force, it is with the consent of the directors present at the majority of the directors present at the meeting also.
Correct. You're right. Considering the LODR requirement and unpublished price sensitive information, when to share financial with the directors for board meeting?
We have discussed already this one.
Yeah. In case of the shorter notice, we require to take the consent of the board in written as a EGM. I'm not getting this question actually. In case of the shorter notice.
Anyway, we will discuss it when the general meetings comes. That time we will discuss the short notice EGMs or AGMs.
Okay. As mentioned by Sudhakar sir, agenda must be sent at least 7 days in advance. if board meeting is being convened by the short notice, how will we comply with the requirement? No, I think there's a confusion there. See, normally the agenda items notice is to be sent 7 days. If we are actually calling the shorter notice with the consent of all the members, the 7 days shorter notice can be done. There is no question of 7 days because you are not calling it 7 days. That is why you are setting a shorter notice consent. Shorter notice can be taken during the meeting, not all. I'm not getting this question, but the thing is, we talked about it. Shorter notice consent is to be taken prior to the meeting. That is, the meeting is actually consented by the people who have the shorter meeting. Yeah. Serial number of agenda can be changed when the minutes are drafted as per the actual discussion taken in serial number. That is question. As discussed, serial number of the agenda can be changed with the permission of the chairman and all the directors. I think it is important when director
No,
leaves.
this I have already explained, Bala. How to draft that, I have already explained this one.
Okay. In the absence of the company secretary, can a CFO, who is also a KMP, convene a board meeting?
He is to be authorized by the board.
In a family-owned business, sometimes the senior directors, the CMD, forget that they consented to the certain decision. So it's important to have everything written when the criteria, when the certain dispute arises in the family business. Years later, there will be a notices maybe sent to the dugout and the providing certain areas that were actually consented. I think this is the view, I think so.
No, it is actually say whenever you are giving the consents, whenever you are giving a decisions, they are to be recorded properly in the board minutes. That is the evidence. Even if people may forget the things, but the board minutes which are to be maintained in perpetuity. That is the evidence.
Notice period of 7 days, excluding day of notice of the stay of receiving. Is this correct? Yeah, absolutely. We talked about 7+2. If the board meeting is to be held through the VC, then can we mention in venue that the board meeting to be held through the VC?
You have to say that in the notice, which is if they are convening the meeting only through VC, you have to say that which is going to be the venue for that particular purpose.
ROC Calcutta had actually filed a criminal case against the company secretary for signing the balance sheet and proper disclosure not there in the place of the report in director report on charging of interest. Ravaya state that the section 129 for signing the balance sheet does not apply to the company secretary. Replacing the accounts can still going on in the court. I do not know what is this relevance of
Anyway,
this
say
particular
this particular question has no relevance for this webinar. He is talking about the company secretary's responsibility when signing the financial statements. Recently, there was a case law also on this that he may refer to that.
Whether the consent to the share of the sharing the unpublished price instructions or chartered notice shall be taken in writing only. Mentioning the minutes is sufficient.
Mentioning in the minutes is sufficient because whatever is there in the minutes that the directors are acceding to that.
General consent is required to be taken in case of the unlisted company. I don't know with the refers to what is the general concern. I don't know. We have no unpublished rights information, but many a time we proceed financial. Other
I
statements.
think, Mr. Bala, the general
Yeah.
consent which Sudhakar said, no, that you take in starting of the year,
Related to UPSI.
UPSI, that they are referring.
Then he says we have no UPSI, but many times we present the financial and other statement during the meeting.
So even see that financially is nothing but UPSI only. Or suppose you forget about UPSI, you are giving certain items not along with the agenda, then you need the consent. For that, you cannot take a general consent.
Our is unlisted company and the audit committee is not a mandatory. However, we have adopted the same. Can we call a meeting on the shorter notice and mention that beginning of the meeting it's instead of a notice?
See, whenever you constitute any meeting voluntarily, also you are supposed to comply with the provisions of relevant sections. Okay. Same is the case here also.
In case of the meeting held in the hybrid or virtual mode, how the attendance is recorded to be maintained? Attendance sheet mentioning mode of the attendance certainly by the CS is sufficient as company need to submit the record of the attendance for the audit purposes for recording, cannot be shared them. Do they really attendance record the certified by the CS? Share screenings, sharing the screenshot of virtual meeting showing director person, whether that can be shared.
No, it is not required. Only the people who are attending the meeting physically, they have to sign the attendance sheet. And the directors who are attending virtually, the company secretary has to authenticate their attendance.
In case of the shorter notice with the UPSI, is it separate entry in SDD required?
Shorter notice, UPSI, no STD is required.
In one of the
That has nothing
parties,
to do with UPSI. Yeah.
in one of the parties to sign the shareholders agreement in JV company, and it is mentioned that in case of the conflict between the articles and the provisions of the shareholders agreement, the provision of the shareholders agreement shall prevail. Shall it be required to incorporate the provision is required? If this is particular case, the JV company is actually contractually bound to comply with the provisions of the shareholders agreement.
See, if you are not incorporating the agreed clauses of the JV agreement in the articles, then the company is not obligated to comply with that. It is a agreement between the two joint venture partners. And if any kind of breach of contract is there, you have to go to the court of law. But if it is a part of the articles, then the company is also a party to that. And it has to ensure the compliance.
In one JV company, the clause relating to the quorum of article of association provides that to form a valid quorum, the presence of the nominee director is a must, but all the director concerned never attend the meeting. Further, after supervision of that particular director, the JV partner so far not mentioning any, so not nominated any director. In such a case, how can the requirement of the quorum as per the article be complied with?
There is a problem in that case, and that they have to resolve that issue. Otherwise, there is a problem in that.
A director has recorded the proceedings of the meeting without the consent of the chairman or the board in such a case, whether such a recording can be as a valid evidence before the court of law.
You can always contest it is not a valid evidence.
Can secretary order ask for the recording of the meeting?
He can at the most say that. He cannot ask for a copy of it. Nobody can ask for a copy of the recording.
Khushbu, your view on this?
And let me also say that the secretarial auditor cannot watch the entire proceedings like a movie. Okay, because in the board meeting, there are a lot of sensitive issues might have been discussed, and nobody else to have privy of that. So what the secretarial auditor, if he wants to watch the recording, what is the purpose for that? If he wants an alibi that the recording has taken place or not, you can show it in the beginning, maybe somewhere for 1 minute in the between, and for the conclusion. That's it. But a secretarial auditor has no right to ask that I want to see the entire 3-hour, 4-hour proceedings right from beginning to the end. He has no right.
Khushbu, you want to add something?
No, sir. Sudhakar sir is very right. Actually, secretary auditors can ask for the minutes of the meeting, but recording is the official document of the company, because in board meeting, various things are going on. Directors are not ready to disclose each and everything. So very complicated matter it can be.
Here, let me also say that even the statutory auditors and secretarial auditors cannot ask for copies of the board minutes. They can ask at the most extracts of the resolutions. That's it. They cannot ask for copy of the board minutes. In fact, when I was in Reliance, we never provided the copies of the minutes to the board, to the people. Please remember that board meeting has its own sanctity. The minutes of the board meeting are available for inspection. Inspection, yes, you can see the minutes. Please go through that. But you cannot take photos of that thing with your mobile, or you can ask for certified copy of the minutes, entire minutes I'm talking about. For your purpose, if you want that extracts of the resolution certified copies, yes, you can ask for that thing.
If only invitees are attending the VC mode, do we need to record the meeting?
Yes, absolutely. I mean, sorry. I mean, what I was actually trying to say, yes, means if the virtual conference, if it is happening and the invitees have joined there, their attendance is to be recorded. But if all the directors present at the meeting, only the invitees are joined through a VC, then no recording is required.
Who is authorized to finalize the consent of the board meeting minutes? If the chairman finalize the same, can other director raise concern that other important matter were not included in the minutes?
Always it is the prerogative of the chairman to finalize the minutes. However, if he is not what's called as included any particular discussion and all, the directors do have a right to bring it to the notice of the chairman. But at the end of the day, it is the chairman's prerogative only what is to go, what is not to go. But only where the chairman is not having a prerogative is the recording the dissent of any director. If a director expresses his dissent, the chairman is under an obligation to record that dissent.
The 4 affirmations to be given by the director for the VC board meeting from the practical convenience, it can be read by the CS on behalf of the directors, which is actually caveat that if not, please let me know. It can be suitably noted in the minutes.
That is wrong. That is wrong. As per the rules, the chairman, the directors have to give the affirmations. You cannot take that affirmations as granted or something like that. It is the company secretary who has to bring it very clearly to the directors. Sir, you have to give these affirmations as per the law. And those affirmations have to be given by them. As a secretarial auditor, you have to also see that if any director is attending the board meeting through a VC, that affirmations have been given and have been recorded in the minutes properly.
In this case, now the roll call is taken by the chairman first for recording the presence of all the directors, and these 4 affirmations is really very important, very necessary for any kind of board meeting.
But in the Act, specifically not mentioned that how to proceed to the shorter notice in the private companies.
It is the rules which are clearly provided. SS1 clearly provided. SS1 is equally applicable to private companies also.
If a director presented through the audio means, is it necessary to maintain the same?
Audio, this thing is now very clear that the presence of the directors at the board meeting is only audio visual. So only audio will not be counted for the purpose of quorum and for the purpose of attendance.
It is as good as he has not attended the meeting. That's all.
Correct. Yeah.
Is it mandatory to record the video recording each meeting, physical or VC, in the company under the SEBI regulations circular?
It is there as per the Companies Act itself. If it is a video conferencing board meeting, you have to record it.
What are the
And
consequences
you have to maintain the recordings up to the next audit. Initially, it was in perpetuity you have to maintain like board minutes, but subsequently, Companies Amendment Act 2017, if I am not wrong, it has said that the rules were amended thereafter, and it said that the recordings are to be maintained up to the next audit. After that, you can dismantle them.
What are the consequences for the members and directors attending the meeting if the compliance is not actually followed during the meeting?
We're going to be taking up case laws to discuss.
Pardon?
We're going to be taking up case laws to discuss the consequences.
Yeah. But consequences is a violation. That's a violation.
No, consequences is different. Here the question is different. What is the responsibility of the directors and the members? So when a board meeting is being taken place, if the director is aware of the certain rules, what is to be done, and if they are not complied with, obviously he has to raise the red flag. Say, for example, quorum is required to be present. And every director knows that quorum is supposed to be there. The quorum is not there and you are deciding it. So it is the responsibility of the director to bring it to the notice of the chairman. In fact, the chairman is supposed to know that. If they are ignoring it, it is the responsibility of a director. Say, for example, if I am a director on the board of a company and they are not complying with the rules, don't you think I have to put my foot down? I have to. Yeah.
My question is to Sudhakar, sir. as you are actually mentioning, the board meeting should be conducted quarterly. However, Companies Act and SSO does not mandate the same. Is it still required to conduct the board meeting in each quarter?
Please read the SS1
I think
properly.
people have to read both. That's what I
Yeah.
think so. Yeah.
Please read the SS1 properly. It is very clearly there.
Yeah. Even Companies Act also it says.
Yes.
Nowadays, many companies are using the board portal where the agenda are uploaded and the directors are given credential to access the agenda. In such a case, there will not be any agenda placed in the table. How that will be deal with the last 2 minutes agenda?
See, when you are, that is electronic means. When you are doing it through a portal, if you are circulating the agenda means electronic means. But what you are not already circulated, but you are bringing it to the on the table, or subsequently you are circulating it as a supplementary agenda, that is there. It is only a mode of circulation. That's it.
Can a director request to change the meeting date?
Why not? It is up to the chairman to change it or not. That is a different thing. But you can always request.
I have a query to Sudhakar sir. If we do not circulate the financial results, even 2 days in advance, since it is an unpublished process situation, and we just table the financial, I think we are not giving the sufficient time to the director to go through the financial and discuss the content. How do we ensure our fair, adequate participation from the directors?
See, if a director is objecting to that, say, for example, if I am a director and you are tabling the financials before me and you are asking my approval, I can always request the chairman to adjourn the board meeting for about an hour or the audit committee meeting. Adjourn it for 1 hour, let me go through that and then come back, or adjourn it for half an hour. Or alternately, let the CFO explain that very crystal clear, whatever he is tabling the items. If the directors are satisfied, that is fine. So it is up to the directors to decide it, whether they want to approve it or not to approve.
In the light of Section 21 of the Act, which permits authentication of the document by a KMP officer or employee duly authorized by the board, can a company validly authorize a person who is not a KMP officer or employee of the company to sign documents that is related to authorization group of the companies or employees that can be that was discussed?
I think if I am not wrong, under the Companies Act 2013, Section 21, he should be an officer of the company.
Okay. I don't know, one complete calendar week. I don't know it's what relevant this is actually put something. Can the board authorize, apart from company secretary, any other official like CEO, CFO, director, etc., for issuing the notice of the board? I think this we discussed. While issuing the notice of the agenda item by email, making them, marking them KMP like CFO, secretarial team member, etc., is it fine? And there are any issue of the compliance as agenda notice is to be issued to the board members? Does board member include KMPs?
If the KMPs, it is not mandatory to circulate the agenda to the KMPs. But most of the times it happens that KMPs are invited to join the board meeting. So it is in all fairness, they have to have the agenda papers also.
As an invitee, we can invite them.
Sometimes it may also happen that you don't need to give the backup, the notes on agenda. You can just give them the agenda only. The 2 papers, the 2 pages or 1 page or whatever it is. Don't give them the agenda papers, that notes on agenda also. That is possible.
Some listed entities have actually special committee meeting for the borrowing committee, investment committee, or executive committee to take borrowing and investment decision. Such a committee do not have actually independent director. This is permitted under Section 179 of the Companies Act 2013. But LODR is silent. Is this okay? Have such committees without an independent director, considering the spirit of the LODR regulations?
Yes, wherever it is, acts are silent, you can do whatever you feel like.
Because these are all non-mandatory committee depending upon the requirement. So I think it is not necessary to comply with those things. If the notice
Bala, it is 12:30. You have SS2 also. Shareholders meeting is there.
Okay, if the notice
So
is sent by the...
So quickly wrap up this thing.
Yeah.
Whatever you have answered, you don't need to repeat it.
Yeah. If notice is sent by the email at the hand, can it be clear 7 days? This we discussed. For conduct the board meeting or shorter notice, there is no that we discuss actually. What are the consequences of members, directors attending the meeting in the complaints if not followed during that also we talked about it. Is it the secretarial best practice circulate draft minutes? Can the director insist the draft minutes to be shown before it is taken up, recorded, confirmed the next meeting? SSO is very clear on the draft minute circulations.
Yeah.
Item like opening of the bank account, demat account, investment share resolution can be taken in 1 or 2 days. How can we proceed with these items? I think this question you have to, we will not answer. What is the remedy if the draft one is not sent within 15 days? Penal action will be there. Already there are decided cases are there actually.
Non-compliance.
Yeah.
Can the board authorize the PCS to assist the convening the board meeting in a company where there is a mandate, there is no mandatory to appoint the company secretary?
Yeah, it can be done.
Can a casting vote used by the chairman in circular resolution?
Technically, yes, he can.
Can the-
Circular resolution is for all purposes is a decision of the board. So where there is a provision for the casting vote, he can cast his vote.
Can
Why
the
not?
case law can the case law can the case law be shared by the CS signing the balance sheet and the criminal case filed by ROC? Recording without the voice can be shared by the auditor if they insist on recording.
No.
No
Auditor
sharing
cannot
is
insist
there.
on recording.
No sharing is permitted at all. At the most, they can be shown what is relevant to them, where they want on the audit point. That's all. The CS may affirm the auditor that the recording of the board meeting is done completely in accordance with the Companies Act. No, they have a right to see whether the recording has taken place. As Sudhakar said clearly, you can show initial starting of the recording, in between the record of the meeting, end of the recording, you can actually show that. That's the thing. If invitees are attending the board meeting through the VC, physical signature is not required in the attendance register, as CS is writing attended through the VC in attendance register. As the SS1 mentioned about only directors attending through the VC and about it, that we discussed, I think.
We've already discussed this.
How long the video recording of the BM shall be kept, that also we discussed actually. Or the video recording of the meeting is to be stored permanently, that we talked about it. As sir, you are saying the copy cannot be shared with the auditor and anyone. Even the major cases of the big auditors, all the auditors are asking for the same in practice. Without the minutes, how can the auditor all the provision has been complied in many things are noted format minutes, as there are auditors can certify the copy of the resolution passed in such meeting. Also, various IPOs and transaction related diligence is being asked. Does company have to deny them?
See, let me reiterate. Auditor may ask for the moon. That doesn't mean you will serve that. You have to see that what is the confidentiality you have to maintain as far as the board meeting is concerned, as far as board minutes are concerned. Who can inspect the board minutes? It is clearly given. It is the regulatory authorities they can inspect. It is the auditors they can inspect the meetings. Inspection is different to that of asking for copies of the minutes. Okay. In case of directors also, it is clearly mentioned that they can inspect the meetings and they can ask for the copies of the minutes also, which is not there for auditors. So auditors cannot ask for the certified copy of the entire board minutes. Only thing is you have to put your foot down. Auditor is asking, the auditor is pressurizing. That doesn't mean you come under the pressure. You tell them what is the purpose, what for they require. Let them read that. No? Let them go through that inspection. You please give it to them. They have a right to inspect the minutes. At the same point of time, because they have to undergo a peer review of their audit also. For that, let them have copies of the circular, the extracts of the resolutions. Certified copies, let them put it on record. That is allowed, but you cannot ask for the certified copy of the minutes. At least I have not given during my tenure as a company secretary in any of the company.
Even I have not given.
Yeah.
I think we stop taking the question here. We are already 12:30. There are another 40-50 questions are there. So let the Justin complete the presentation. Then we'll take it up. Yeah.
So
Justin.
Jaswin, what I suggest is that quickly you just go through the other things, SS2. Because, of course, SS1 is always more important. That's why this many number of questions are also there. So I am actually justified in, okay, at Mehta and Mehta, we are justified organizing this particular webinar. That means we are really choosing a good topic and a good presenter also. At the same point of time, whenever I said that SS1 and 2 are to be repeatedly read as Bhagavad Gita, that also I am justified in saying so. Yeah, go ahead with SS2 now.
In
Wonderful.
fact,
Thank you so much.
in fact, increasingly ROCs are referring the secretarial standard for many of the adjudication orders. They are also referring the guidance note verbatim. They are actually producing what is expected to be by the employee secretary, even in case of the secretarial auditor guidance note, especially when it comes to the related party transaction. It becomes very, very important even from the regulatory point of view. Yeah, go ahead, Jaswin.
Yes, sir. So, short note on meeting of the committees before I take up the shareholders meeting and SS2 related matters. So, on meeting of committees, there is no provision under the Companies Act that specifies the manner of conduct of committee meetings. However, SS1 specifies that the principles enumerated in SS1 relating to the meeting of the board are also applicable to the meeting of committees to the board. And SS1 defines committees as committee of directors mandatorily required to be constituted by the board under Companies Act 2013. So for all these kind of committees, SS1 will have to be followed accordingly. Meeting of the shareholders. So, going on to the annual general meeting. So, every company other than an OPC shall in every year hold, in addition to any other meeting, a general meeting, which will be known as the annual general meeting, and shall specify the meeting as such in the notice calling it. So, whenever we're drafting a notice for the AGM, it shall specifically mention that this is for the annual general meeting, and it shall be held not more than 15 months between the date of one AGM to the date of the next AGM, and within a period of 9 months from the date of the closing of the first financial year of the company, and in any other cases within 6 months from the date of the closing of the financial year. Extraordinary general meeting. Any shareholders meeting other than the annual general meeting shall be referred to as the extraordinary general meeting. Types of business that can be considered in case of AGM and EGM. This is being done so that because the drafting itself will change, there'll be certain variations in the drafting of the notice according to the type of business being considered. So, ordinary business means business to be transacted at an annual general meeting only, relating to the consideration of financial statements, consolidated financial statements, and the reports of the board of directors and auditors. Second kind of ordinary business at AGM is declaration of any dividend, appointment of directors in place of those retiring, and the appointment and fixing of remuneration of the auditors. If these four kind of agenda items are done at annual general meeting, the AGM, then it is referred to as ordinary business. Any other agenda item other than the ordinary business transacted at the annual general meeting, and all the business items transacted at any other meeting shall be referred to as special business. Coming to the SS2 requirements as well as Companies Act, the authority of convening a shareholders meeting. The board shall every year convene or authorize the convening of the meeting called the annual general meeting to transact the items of the ordinary business specifically required to be transacted, along with special business, if any. In case the board fails to convene an annual general meeting in any year, any of the members of the company may approach the NCLT, which may then direct the calling of such annual general meeting. In case of extraordinary general meeting, the board may, whenever it deems fit, call an extraordinary general meeting of the company. Additionally, an EGM can also be requisitioned by the members. So the board shall, on the requisition of members who hold, in case of company having a share capital, at least 1/10 of the paid up share capital carrying voting rights. If such number of people requisition the EGM, or in case of company not having share capital, not less than 1/10 of the total voting power of the company can requisition the calling of an extraordinary general meeting. Now, in case of receipt of a valid requisition on behalf of such members, the board shall within 21 days from the date of the receipt of the requisition, if the board fails to call the meeting on any day within 45 days from the receipt of the requisition, then the requisitionists themselves may call the meeting of the shareholders within 3 months from the date of the requisition in the manner in which the board would have called such meeting. In case the EGM is being called by the requisitionists themselves, then the explanatory statement need not be annexed to the notice of the EGM convened by the requisitionists. And the requisitionists have to disclose the reasons for the resolutions, which for the purpose of which they have called for such meeting. Specific provisions related to Secretarial Standard 2 on the notice of the shareholders meeting. The notice in writing shall be of every meeting shall be sent to every member of the company, and the notice shall also be given to the directors and auditors of the company, along with the secretarial auditors and debenture trustees.
Here
The
only
notice.
please remember when you say it is member of the company means if you have preferred shareholders, you have to give the AGM notice and annual report even to the preferred shareholders also. They have a right to attend the meeting, but they cannot vote thereat unless until they acquire the voting rights because of non-payment of dividend for a period of over 2 years. Yeah.
Sudhakar, 1 minute. I have having technical issues, so I'm leaving it. Sorry. Thanks, everyone.
Okay. Yeah, go ahead.
No issue,
So
no
the
issue.
note-
Carry on, carry on. Yeah.
Notice shall be given or served at the shareholders' address registered either with the company or the depository, which is CDSL or NSDL. The shares or any other security is held jointly by, in case they are held jointly by 2 or more persons, the notice shall be given to the person whose name appears first as per the records of the company or the depository. The notice shall be sent by hand or by ordinary post or speed post or registered post or by courier, fax, email, or any other electronic means. The SS2 has also defined electronic means to detail that any communication sent by the company through its authorized or secured computer program, which is capable of producing confirmation and keeping a record of such communication addressed to the persons entitled to receive the communication, at the last electronic mail address provided by the member. The proof of sending of the notice shall be preserved by the company for a period of not less than 3 years from the date of the meeting. And in case the directors, auditors, secretarial auditors, the address at which it is to be provided with the notice and accompanying documents shall be the email address that is provided to, by them if it is sent by electronic means. The notice shall be sent to the members by registered post or speed post or courier or email, and not by ordinary post. There is an exception is only in the case where the company provides the facility of e-voting, or if the item of the business is being conducted through postal ballot. In such case, ordinary post cannot be used for service. If any member requests for delivery of notice through a particular mode other than the one already followed by the company, then he shall pay the fees applicable as may be determined by the company at its AGM for such particular service to them. Notice shall be sent to the members by registered post or speed post if the meeting is called by requisitionists themselves, where the board has not proceeded for calling of the meeting. In case the company has a website, then the notice shall compulsorily be hosted on the website of the company till the conclusion of the meeting. The contents of the notice of the shareholders meeting. The notice shall specify the day, date, time, and full address of the venue of the meeting. And the notice of the annual general meeting shall also specify the serial number of the meeting. This is a particular requirement under SS2. The notice shall contain complete particulars of the venue of the meeting, including the route map and the prominent landmark, if any, for the ease of location. The route map can be excluded only in certain cases, which is if the company is a company in which only its directors or their relatives are members. So it's a family owned, closely held company, or a wholly owned subsidiary, or where the meeting is being held purely by video conferencing. Only in those cases, route maps can be skipped. Otherwise, in all the notices for shareholders meeting, the route map has to be provided. Provisions related to date, time, and venue of the shareholders meeting. In case of an annual general meeting and a meeting called by requisitionists, the meeting shall be called during business hours, that is between 9 a.m. to 6 p.m., and a day that is not a national holiday. The AGM shall be held either at the registered office of the company or any some other place within the city, town, or village where the registered office of the company is situated. However, in case of AGM of an unlisted company, that can be held at any place in India if prior consent is given by all the members, either in writing or by electronic mode. Such consent shall be received before or prior to conduct of the meeting itself. In case
This
of
way you have to
EGM,
gallop. Now you have 44 slides and you are at 27.
yes, sir, I'll just take it a little more faster. In case of EGM may be held within any place in India. And in case of wholly owned subsidiary of a company incorporated outside India, EGM can be allowed outside India as well. A meeting called by requisitionist shall be held either at the registered office or within the city, town, village where the registered office is situated. The notice of the shareholders meeting shall have a particular clause may provide for appointment of proxy. So it should, if the articles provide for the same, then the voting at a meeting by proxy shall also be provided in the meeting. The explanatory statement, in case of special business being transacted, the special business to be transacted at the meeting of the company relates to or affects any of the other company, the extent of the shareholding interest in that other company of every promoter, director, manager, or any KMP. Shall be mentioned in the explanatory statement if the extent of the shareholding is not less than 2% of the paid up capital. In case of appointment or reappointment or fixing of remuneration of directors, including MD, executive director, or whole-time director, or manager, or variation in the terms of the remuneration, the qualifications, experience, terms and conditions of appointment or reappointment, along with the remuneration sought to be paid, shall be mentioned in the explanatory statement. In case of appointment of independent director, the justification for choosing the appointee as the independent director, or along with their qualifications and a performance evaluation report in case of reappointment, shall be included as a part of the explanatory statement in the resolution in the notice calling. Okay, the time period for service. The notice of the shareholders meeting along with the accompanying documents shall be given at least 21 clear days in advance of the meeting. So, and in case it is being served by post, then 2 additional days have to be considered. Now, clear days means the date of dispatching the notice and the date of the meeting itself have to be excluded for the purpose of this calculation. So like sir had mentioned already, so it's 21 plus 2 in case it is sent by post. The notice and accompanying documents may also be given at a shorter notice if the required consent of the members in writing is accorded thereto, either by physical or electronic means. In case of AGM, the consent by not less than 95% of the members. And in case of financial statements and other documents that are required to be annexed to the notice, in case of shorter period service of the same, then the consent has to be obtained by majority of the members in number and holding at least 95% of the paid up share capital of the company. In case of any other general meeting, the consent has to be obtained from majority number of members in majority holding at least 95% of the paid up share capital. And such consent has to be obtained prior to the meeting.
See, only here I would like to add one or two things. In case of the shorter notice consent, you required to have that before commencement of the meeting. The time of dispatch of notice, even if you are not having shorter notice consent, still you can send the notice. But you can commence the meeting only when you have the shorter notice in hand, number one. Number two, if you are having 95% consent, shorter notice consent, then you cannot hold the meeting on the very same day, because if you have 100% consent, then you don't need to comply with the proxy related provisions. But if you are having 95% consent with you, for the remaining for 5% of the people, they can avail the proxy related provisions. So you have to have the meeting only after 2 days. Very elaborately, we have explained this in the guidance note of SS2 and as well as SS2 itself also. Please go through that. Okay.
So the SS2 itself mentions that no business shall be transacted at a meeting if the notice is not in accordance with the secretarial standard. And any accidental omission to give the notice to or non-receipt of such notice to any of the member or any other person entitled shall not invalidate the proceedings of the meeting itself. Further, the resolution shall be valid only if it is passed in respect of any item of or business contained in the notice convening, or if it is specifically permitted under the Act. Any amendment to the notice, including addition of any item of business, can be provided to the by way of the notice amendment, and shall be served at least 21 clear days before the meeting. The notice shall be accompanied by an attendance slip and a proxy form with clear instructions for filing, stamping, signing, and depositing the proxy form. In case of any reasons beyond the control of the board, a meeting of the shareholders cannot be held at the date originally fixed. The board may reconvene the meeting to transact the same businesses specified in the original notice after giving not less than 3 days intimation to the members. And the intimation shall be either sent individually in the manner stated in the secretarial standard, what we have discussed, or published in the vernacular newspaper in the principal vernacular language of the district where the registered office is situated, and an English newspaper having wide circulation in that district. Specific provisions in case of shareholders meeting by video conferencing. The notice for meetings should clearly mention that the meeting will be held by video conferencing or other audio-visual means, along with the reference to the circulars issued in this respect. The place of the meeting shall be provided in the notice, which shall be a deemed venue in case of such meetings, and no road map shall be required if the general meeting is being held virtually. The notice for the general meeting shall make disclosures with regard to the manner and framework provided and available for use of the members, and also contain clear instructions on how the members can access such a meeting. In case the notice to the AGM, it may be mentioned that the shareholder who wants to speak at the AGM, in case of meeting held by video conferencing, they have to register themselves, and they will be allowed to speak with the discretion of the chairman. And a copy of the meeting's notice shall also be displayed at the website of the company. Certain additional provisions related to notice in case of postal ballot. The notice shall be accompanied by the postal ballot form with necessary instructions for filing, signing, and returning the same. And the notice shall specify the day, date, time, venue, where the results of the voting by postal ballot will be announced, and the link of the website where the results will be displayed. The notice shall inform the members about availability of e-voting facility, if any, and also provide necessary information to enable them to access such e-voting link and facility. The notice shall also clearly specify the date and time for commencement and the end of the e-voting. And each item proposed to be passed through postal ballot shall be in the form of the resolution and accompanied by an explanatory statement which sets out the facts related to the agenda item so that the members can understand the meaning, scope, and implications of the item. In case of certain other meetings that are mentioned under the act and how are they to be conducted, one is the meeting of the independent directors. So regulation 25(3) of the LODR regulations mentions that the independent director shall hold at least one meeting in a financial year without the presence of non-independent directors, and the members of the management and all the independent directors shall be present at such meeting. So we're just taking up how this meeting would be conducted. The motive of this meeting or particular important agenda items would be to review the performance of the non-independent director and board of directors as a whole, review the performance of the chairperson of the listed entity, and to assess the quality and timeliness of flow of information between the management and the board of directors. So the company secretary, wherever appointed, shall facilitate the convening and holding of such meeting if so desired by the independent directors. Meeting of preference shareholders and debenture holders. So the principles enumerated in SS2 for general meeting of the members are also applicable mutatis mutandis as the case differs to meetings of the debenture holders, preference shareholders, and creditors, which is the class meetings. So the last topic for discussion is certain case laws related to notice, where the ROC and the other authorities have highlighted the importance and implications and consequences of non-compliance with these provisions. So one such order is by ROC Bangalore in the matter of United Telecoms Limited. So the Registrar of Company Bangalore had passed an adjudication order penalizing the managing director, whole-time director, and the then company secretary of the company for 30,000 rupees each. And this was levied on them since they had not provided a proper explanatory statement while issuing the notice for convening the EGM for appointment of an independent director. Next is the order by ROC Mumbai, wherein the company did not circulate the notice to the meeting, notice to the members and the directors for an AGM. And in that case, they were penalized for the same for non-compliance under 101 of the Companies Act as well as the secretarial standards. A Supreme Court judgment in the case of Life Insurance Corporation of India versus Escorts Limited, a very celebrated and famous case law, wherein the LIC challenged resolutions passed by the company's board, where procedural requirements, including notice, were not complied with. So the court, while passing this judgment, emphasized the strict adherence to the procedures and formalities and the corporate governance norms, including timely service of the notice, and the failure to comply can affect the very validity of the board decisions. So the principle that was highlighted, and this is the procedural compliance, including notice, which is very vital and critical for the validity of the meeting and the decisions taken. With this, I come to the end of my presentation.
Very good. Yes, Bala, you can take up a few questions if you feel like it. It's already 1 o'clock.
Yeah. In after he has come to know. But when you are seeing a video recording in the initial only, the roll call is the starting point. How can you say you are actually forgotten or something like that? I think it appears to be something a hypothetical question because it has to be started, roll call is to be taken as I explained. Then how to delete the recording after the next audit, maintaining of the record till the next audit also applicable to the general meeting or only to the board meeting?
Only to the board meeting.
How to delete the recording after the next audit? Yeah.
See, recording is mandatory only for board meetings, not for the general meetings.
When a director is attending, director has to leave the meeting and rejoin later after the resolution is passed.
You can do it and you record the minutes accordingly.
Okay. Sir, can a company authorize anyone else who's not the employee? That I think we discussed this
We
actually.
discussed it already.
In
Yeah.
case of the, in case of the two directors, there are only one person become the chairman, and how the resolution will be passed by the single person in most private company cases. Whether
There are two directors
chair-
are there now. So one become chairman, so what? He is continuing to be a director also now.
one will act as a agreement of the permanent observer entitled to attend the board meeting. Is it allowed?
Yeah, it is allowed.
If the borrowing resolution was not taken, however, the transaction has happened. So the same can be ratified with the company board meeting or approved mandatorily. Company is the private limited company. No, it is a non-compliance. Penal action will take place actually. What is required to be approved by the board, it is required to be approved by the board. Even the tax department asks for the minutes. How to deny them?
Tax department never ask for board minutes. They will ask only for resolutions.
Can the secretary ask, say the secretarial auditor ask for the minutes copy for their references? They are asking their records and understand the compliance of the SS1. Can they have a copy of that? Kushbu, secretarial auditor.
Already discussed this, sir.
In
He
case
can
of the
inspect. Yeah.
in case of the government company, CAG is asking for the notice agenda and board minutes.
We have to be strict for this, sir.
See, let me tell you, Bala, it is actually the company secretaries. By default, people used to give certified copy of the minutes to the whoever is asking for that without understanding the importance of the board minutes. Only of late, when we started telling, even in fact, let me tell you, in Reliance, when I was working also, my colleagues, I mean, they used to give sometimes. When I came to know about that, I told them very clearly not to give the certified copy of the minutes to anybody. And the auditors raised a big hue and cry, and we told them very clearly, "But you are not entitled for the copy of the minutes. Please go through that as many times as you want. Whenever you feel like, we can give you inspection, but not copy of the minutes." Similarly, management representation letter by the secretarial auditors. People used to take 40, 50 pages management representation letter stating that the company has maintained the minutes as required under the Companies Act. Why you want a management representation letter? You are the person who is doing the audit. Why I have to certify that I am maintaining the minutes? In fact, the same thing had happened in Reliance when I was there. The first time when the secretarial auditor, he came with a 40 pages management representation letter. Ultimately, we gave only 1 page management representation letter. We will give that management representation only for those things which you are not feasible for you to do it on your own. Say, for example, the company is maintaining the books of accounts. You may not be able to certify that. For that, we will give an MR to you. The company has displayed the board, what's called as the notices, or wherever our offices are there, we are displaying the what's called as the company's notice and all prominently. We will give it to you. But not that we have a proper board, we have the constitution of the board is as per the listing regulations. That is your duty, bhai. Why we have to give an MR to you?
Does holding of the quarterly and 4 meetings in a year also apply to the audit committee and other committees? As
Yes.
companies does not act to specify specific numbers of the period of the meeting of the audit committee.
See that if it is silent, the Companies Act is silent about it. But if you see the listing regulations, audit committee 4 meetings are required, risk management committee 2 meetings are required, other committees 1 meeting is required in a financial year.
Is it the appointment of the auditor is ordinary or a special resolution? I will not answer this question because you should know what is the ordinary business, what are the to be taken in the AGM. It's all well laid out, fundamental. This question is not to be answered.
If
Whether
it is a
SS
secretarial auditor, still I can understand. If it is for auditor, it's not worth answering that question.
Correct. Whether the SS1 is applicable in the voluntary committee, of course, we discussed this actually. Any committee you constitute voluntarily, it is applicable. Is it mandatory to take the
No,
board
SS1
meeting
is, no,
minutes?
sorry, Bala. SS1 is not applicable. SS1 is applicable only to the
Sorry.
committees which are.
Sorry. I thought the Companies Act. Sorry. Companies Act is applicable voluntary committee. Yeah,
Correct.
you are right. Yeah. Then I read up the question. Whether SS1 applicable to the voluntary committee of the board or borrowing committee, investment committee under section 179. Further, whether
See,
the
let me
disclosure
tell you one thing,
voluntary
okay, that let me clarify. SS1 is applicable only to the committees constituted under the Companies Act, not under the listing regulations. Say, for example, RMC, Risk Management Committee, is constituted under listing regulations. Technically speaking, if I am not complying with SS1 for RMC, I can do away with. Governance point of view, you comply with, that is all different thing. But technically, answer is no. Yeah.
Correct. Further, whether the disclosure of the voluntary committee meeting needs to be disclosed in the form MGT 7 annual return.
Not required.
Not required. Is it mandatory to take note of the board meeting minutes in the subsequent meetings?
Yes, it is required. You have
It
to
is
be taken a
required in the
note of.
subsequent.
Only
Yeah, it
noting.
is correct. Kindly clarify whether the appointment of the second auditor is to be included in the ordinary item or the special business item.
Special business.
Ratification of the remuneration of the cost auditor is ordinary business and can it be taken in the EGM?
It is not ordinary business. It is a special business.
Can a CFO being a KFB is an off-role employee?
It cannot be.
Whether the notice of the AGM also need to be sent to the cost auditor and the internal auditor?
See, as far as that CFO is concerned, he need not be on the roll of the company. He can be seconded also, Okay.
Whether the notice of the AGM also need to be sent to the cost auditor and internal auditor?
Technically not required.
A company not ready to, company is not ready with
please,
the auditor.
just 1 minute, Bala. Please appreciate what is the role of the cost auditor. Role of the cost auditor is very confined only to the cost related issues, not to the entire company as such. Whereas secretarial auditor and statutory auditors are concerned, they are conducting virtually the whole of the affairs of the company. But similarly, Companies Act is silent about secretarial auditors, whether the AGM notice is to be served or not. That's why while we were drafting the SS2, we have brought that very clearly. Secretarial auditor is also to be given the notice of the AGM. Yeah.
A company is not ready with the audited financials by 30th of September, hold the AGM and adjourn the same to be held in January the following year and present the auditor financials before the adjourned meeting. Is it the violation of the section 96?
Yes, of course.
Of course it is. Because you would have applied for the adjournment. Adjournment can be given only for the 3 months by the ROC extension. Beyond that, it is not. It is necessary to give a notice to the postal ballot to auditors.
Yes.
So now, since the proof of the sending the notice of the director is required to be stored for the 3 years, but for example, there is a practical situation where a consultant is being asked to do the previous annual filing for the company, and he says for the year 2020, then in that case, company can say that it is not required to store for more than 3 years, and therefore we do not have the copies. In that case, a consultant who is actually certifying MGT 8 and the secretarial audit MR3 for that period, can he provide a qualification in his report, or can the company submission can be taken?
This is some practical question, Bala. Let us skip this thing.
Okay, can you please share the PPT? PPT is not shared a recorded version of the seminar is actually disseminated, which contain the PPT. You can actually have that. There's no issue. Can any agenda be added to the notice of meeting after dispatch of that? We discuss actually. Who will prepare the minutes of the meeting? Independent director, and whether the same can be placed in the next board meeting or not.
In case of independent directors meeting, no minutes need to be maintained in the minutes form, but only recordings are advisable to have it, and they need not be placed at the next board meeting.
Please confirm whether it is mandatory to attend a notice of the AGM in AOC 4. Mandatory to attach the notice of the AGM to AOC 4. I don't think so. Notice is not required.
To my knowledge, Shahid, it is not required. To my knowledge,
It is not.
Not
It is not
mandatory.
required. It is not required actually.
Not mandatory.
Okay. I think hats off to the session, wonderful presentation. Is it necessary to publish advertisement pre-dispatch and post to postal ballot notice as per the MCA General Circular dated 5/5/20?
please read the circular. If it is to be published, you publish it here. Okay.
Board minutes can only be asked by the court order. Somebody is given the information. Can internal auditor of a company insist upon a copy of the audit committee minutes where internal audit report issues are recorded?
No need to give minutes copies to anybody.
Is it mandatory that the CS or a WTD or a CEO must be a whole-time employee?
Not necessarily. You can have, see, whole-time director, obviously, he has to be on the board of the company.
Yeah,
as far as CS and CFO are concerned, you can second them.
I think that is all. We have come to the end of the questions. Questions are actually over.
See, two, three
Anybody
things,
has
from this summary, I
anybody-
want to summarize one or two things, Bala, that number one, this mindset of that we have to provide the minutes of the board meeting or the committee meetings. Please erase it from your memory. You have to put your foot down because you are a legal person. You have to talk to the people legally. Don't talk to them with the, whatever the convention you are conventionally, you might be giving it to them over a period of time. But the things have changed. Your responsibilities have changed. Your accountabilities have changed. So don't go and circulate copy of the board minutes or committee minutes just like pamphlets or brochures of the company. You have to resist that, number one. Number two, whenever you are preparing a notice or agenda and all, first and foremost thing is before you are pulling out the previous agenda copy or a notice copy or somebody else's AGM notice and all, first of all, see what are the ingredients you are going to put into the notice. Once the ingredients are ready with you, then you go for the recipe. Just like, that our mothers and sisters, they used to prepare the food. What they do, first of all, whatever the ingredients are required, they put it at one place. After that, it is a recipe. That is the method of cooking. Same is the case in the notice also. First of all, you have to make up your mind. What are the contents of the notice as per the law, as per the SS1 or listing regulations are required. After that, you please prepare your own, then you compare it. That point of time, you will come to know what are the flaws. If you are merely copying something, your mind will be working in that four corners of the wall only. You will never be think out of the box. Yeah. Well, I may conclude. I think it is already 1:15. Bala, you are on mute, I think. Bala, you are on mute.
Mogi, Sarija and Naveen, are you there? If you are there, you can unmute, you can talk yourself. Naveen? Mohit? I don't see them actually. I think we can conclude because we are already almost about 116 or something like that.
Yeah.
Let me tell you one thing. By looking at the attendees and by looking at the deliberation, by looking at the questions, it is a very, very worth webinar what we have selected and conducted. Heads up to Mr. Sudhakar providing the excellent thing. Heads up to Kushbu for providing the insight from the point of the secretarial audit, etc. I personally enjoyed this particular session because with so much of the introduction and other thing and all, although I also thought initially it is a small topic, it will get over by about 12:30 or something. That is what I thought in the beginning actually, but I never thought it will go such a things, so much clarification, so much doubt, so much intricacies, so much things which are actually involved. Time has changed between 1956 2013. It is a sea change. I think we'll have to gear up ourselves, as Sudhakar puts it. We'll have to continuously apply our one. We'll have to raise our war, and we'll have to keep it, and we'll have to put down what you call courage of conviction. That needs to be there, understanding the thing. That is actually the case.
But Bala,
With
let
that,
me
I
also
take opportunity.
Bala, let me also say that because this is the AGM time and the closing of accounts time, that's why we thought last week we had BRSR, this week we had a notice. Next week we are going to have on the board's report. So I think I'm giving advance notice to the participants so that they can prepare themselves. And very soon we are going to send the flyer also about next week webinar is going to be on the board's report.
Thanks a lot.
Yeah.
Thanks, Kushbu. Thanks a lot, Sudhakar. And my special
Thank you.
thanks to Jasmine, because she has excellently captured everything and he has put up everything and he has brought out the case laws as well. Thanks. You have done a wonderful job, Jasmine. By looking at the partisan itself, you know what is the importance of it. You are nicely presented. Thanks a lot to everybody. We yet meet in the next webinar and we close the seminar with this. Have a good day. Thank
Good
you.
job, Jaswin. Thank you very much. Thank you,
Thank you,
Kushbu.
sir.
Thank you very
Thank you
much.
so much.
Bye-bye.
Thank
Yeah.
you.